Well, good afternoon, everyone. Thank you for joining us in this Irwin Mitchell webinar, Employment Issues Following a Diagnosis of Cancer. This is one of a number of webinars that we've been hosting during this season in order to connect with our clients, colleagues and communities. So a very warm welcome to you. Thank you for joining us this afternoon, or if you're catching up with the recording at a later date, thank you. My name is Simone Hardy. I'm a solicitor and senior associate in our complex personal injury teams. I'm based in Sheffield, and my particular area of specialism is in personal injury claims for workplace illnesses, in particular for people diagnosed with cancer as an unfortunate consequence of being exposed to asbestos, generally in their workplaces many years ago. So that's my particular area of expertise, and in a few moments I'll hand over to my colleague Glenn Hayes, whose area of specialism is employment law. So Glenn is a partner based in Leeds, and he heads up our employment law teams across our northern offices. We're very grateful to Glenn today for sharing his knowledge with us on these employment law issues. So I know many of you listening will work in health and social care, perhaps supporting patients with cancer in different roles, or perhaps as a welfare benefits advisor or as a HR advisor. So whatever your role in supporting people with cancer, just want to say a big thank you to you for supporting people at what's obviously a difficult time in their lives, and no more so than in this current health pandemic as well. So thank you for all that you do, and thank you for joining us today. So you can post any questions during the webinar. You can do that on the Q&A panel at the side, and we'll try and take those, if not as we go along, then at the end we'll come to those. And we did have a few questions notified in advance, which we'll pick up as well. So we expect the webinar to be perhaps about 45 minutes long. If we do have any transmission difficulties, we'll re-record it another time, and in any event you will receive a recording by email of the webinar that you can catch up with later or share with your colleagues. So we hope it's helpful to you, whatever your role. Thank you for joining us, and I'm very pleased now to hand over to my colleague Glenn. As I say, Glenn is an expert in employment law, and he heads up our employment law teams across our northern offices at Irwin Mitchell. So thank you, Glenn.
Thanks, Simone. When I was asked to do this, I was delighted to do so. I've done it actually once before, but just to sort of let you know a bit about myself. So I've worked at Irwin Mitchell coming up for 20 years, head up the northern employment teams, and actually I've got quite an interest in cancer because actually it's my brother's 40th birthday today, but in January he was diagnosed with terminal cancer, was given 12 months to live, and now the diagnosis has changed slightly. He's got between 5 to 8 years, but he's receiving treatment and advice and support from Macmillan and other organisations. So I'm delighted to try and pass some knowledge on to people who are working in that area. So in terms of what I'm going to cover today, then what I'm going to talk about is the sort of general law in relation to sort of unfair dismissal and disability discrimination, which is the sort of two main areas of employment law where this would where cancer sufferers would be impacted. If you just move the slides on, Olivia, please. So I'm going to start off with unfair dismissal then. And I'm going to assume for this purpose that everybody on the call sort of knows nothing really about sort of unfair dismissal, and other than the very basics of what it is. But in an unfair dismissal case, the initial burden falls upon the employer to show that the reason, or if there's more than one reason, the principal reason for the dismissal was one of the 5 permitted reasons to terminate somebody's employment. So those are capability or qualifications, and it's capability that we'll be talking about in a dismissal on the grounds of ill health, conduct, redundancy, inability to work in a position without contravening an act of Parliament. So, for example, if you're a taxi driver and you lost your driving licence, and the catch-all or some other substantial reason. So if an employer can satisfy that the dismissal was for one of those statutory reasons, a tribunal then goes on to assess the fairness or unfairness. And in doing so, they take into account the size and administrative resources of the employer, and really decide whether it's acted reasonably or unreasonably in treating that reason as a sufficient reason for dismissing the employee. Now, before we get to that stage, it is quite important to realise that not everybody can bring unfair dismissal claims. So you can only bring an unfair dismissal claim if you are an employee. Okay, if you've got the requisite 2 years service to bring a claim for unfair dismissal, so you don't necessarily need that if the decision is dismissal is disability related in a cancer claim, and if the claim's been lodged within a 3-month time limit of the act of dismissal itself. So the first point I said to you there was really whether an individual is an employee. Sounds very straightforward, but actually it's not. Some people will be fairly straightforward as employees. Those who are self-employed, however, will not have this protection, and those who are workers will not be able to bring a claim for unfair dismissal, but they may be able to bring one for discrimination. So when assessing the fairness of a dismissal, a tribunal will focus on 2 basic areas. Firstly, they'll look at the procedural elements of the employer's decision to dismiss, and then it looks at the substantive decision and in particular the grounds on which the dismissal is decided upon, the quality of the investigation and evidence on which the decision is based. Now, in terms of what that actually means in an unfair dismissal case based on capability, then the tribunal really will look at what the employer did at the time of dismissal in terms of carrying out a process and making its decision, and decide whether the employer has acted in what we call a range of reasonable responses. So for dismissals based on capability, what they'll really look at is, has the employer made a proper medical investigation? So has it done its homework and looked into what's wrong with the individual and sat down and actively discussed that with the individual concerned? So has there been proper consultation with that employee before taking the decision to dismiss? Did they properly consider the requirements of the business and balance those against the need for the employee to have a reasonable time to recover? So if you imagine it a bit like a weighing scales, you've got the employee's needs on the one hand and you've got the employer's needs on the other to get the job done. And ultimately, if the employer's needs to get the job done as such that it causes them a real problem, and that problem can't be alleviated, and they can't wait for that individual to come back and recover, then ultimately they may be able to terminate the individual's employment. And it is really important that if you are advising people who are facing potential dismissal, if there is a prognosis that they may be able to return within a certain period of time, and they believe that it's reasonable for the employer to wait, for that individual to then state why it's reasonable for them to wait, what can be done in the meantime, how quickly they can come back, whether there's something whether they can come back on a phased return, for example, to try and balance up that scales back on the employee side if that's who you're advising. Now, one of the duties on the employer is whether they've made suitable adjustments to try and facilitate the employee's return to work. Okay, if there's no magic number in terms of how long an employee is off for before an employer will be deemed to be reasonable in effectively saying to somebody, right, okay, unfortunately we're going to have to dismiss you from your employment. So it's not like a 3-month or a 6-month threshold or anything like that. It will depend on the circumstances of the case. So for example, if you've got an individual that works in a team of 12 people and their work can be covered by the other 11, it may be easier to absorb that person's responsibilities, okay, amongst the 11 people and wait a bit longer. If that individual is the finance director for the entire organisation, you're coming up to it, the employer's coming up to a year end and need to file some statutory accounts, for example, then again, the timescale might be less in that example than in my team of 12 pool. So the tribunal will look at whether the employer's made adjustments, but they'll also then look at whether the dismissal on the ill health grounds was substantively fair, taking into account all the relevant circumstances. So there are hoops for the employer to jump through, okay, before they can fairly dismiss anybody, and including whether they've given the individual a proper right of appeal. So that's really how tribunals will assess the fairness of a dismissal, and I think it's important that you have that general overview if you are advising somebody who's potentially facing the termination of their employment. Okay, you just move the slide on, please, Olivia. So the next sort of large section of the Act really then is about the talk then is about disability discrimination, and again I think it's all the claims now should be brought under the provisions of the Equality Act based on one or more of protected characteristics. So in this case we're really talking about the characteristic of disability, but it's not just, it doesn't just cover employees here, it also covers workers both during, pre and post employment. Okay, so if I apply for a job at an employer and I have cancer and disclose that on my application form, and the employer turns me down on that ground, that prompts a claim in itself, even though I've never worked for that employer for a day. Okay, or it could prompt a claim. Discrimination can affect various different aspects of employment, and I think it's important that we've got a general understanding of that. It's not just the employment itself, but it could be the recruitment process, it could be the terms, conditions and benefits that an employer offers to an individual, and also the opportunities for promotion and training. So if somebody's, for example, overlooked for promotion because they've got cancer or for reasons related to it. So in order to understand disability discrimination, I think it's important to understand what the definition of a disability is. So that is somebody who has a physical or mental impairment. Okay, so fairly self-explanatory, that part of it. But that impairment has to have a substantial and long-term adverse effect on the ability to carry out normal day-to-day activities. Okay, so substantial means more than minor or trivial. Long-term means has lasted or is likely to last more than 12 months. Okay, and it has to affect somebody's ability to carry out normal day-to-day activities. So, for example, their ability to carry the shopping in from the car, the ability to effectively concentrate whilst at work, not fall asleep, those types of things. But the important thing for the purposes of this talk is that cancer is treated as meeting the definition of disability under the Equality Act from day one of diagnosis. So you don't need to go through the whole, what can often be a debacle of determining whether somebody meets the definition of substantial or whether it's likely to last more than 12 months, which includes taking away the effect of medication to see what effect that has. Cancer sufferers are automatically treated as covered under the Disability Discrimination Act as was, the Equality Act as is. Okay, so can you move the slide on, Olivia, please? So there's various different strands of discrimination then, and most claims will be for direct discrimination, which is set out in section 13 of the Equality Act. And that's where a person, A, if you like, discriminates against another, B, because of a protected characteristic and treats them less favourably than they would treat somebody who doesn't share that protected characteristic. Now, effectively what that means is that if I treat a person without cancer favourably compared to a person that with cancer less favourably, then I am guilty of disability discrimination. And direct discrimination such as this cannot be justified under any circumstance, okay, unless the protected characteristic is age. So if I treat the non-cancer person favourably compared to the cancer person, I cannot justify that as an employer. Okay, but it's less favourable treatment of itself isn't enough. It has to be a comparison. So if I treat all of my employees unreasonably or unfairly, whilst it's not the greatest way to run my business, it doesn't mean that I discriminate against them. Okay, so you have to do some element of comparison, either an actual comparator or a hypothetical one. Okay, and if it's to be a valid comparator, the relevant circumstances has got to be the same or not materially different to the person, to that of the complainant. So in effect, what you've got to compare like against like. Okay, so if, for example, a woman complains she was unsuccessful in applying for a vacancy, but a man was, it doesn't necessarily raise an inference of sex discrimination, for example, unless she's able to show that she's equally as qualified as the male comparator, and you can put that into the cancer setting as well. So now, again, there has to be a causal link, so that the tribunal needs to be satisfied that the less favourable treatment is because of the protected characteristic. Okay, but it doesn't have to be the sole cause of it. It has to be the effective cause. Okay, and again, it doesn't need to be intentional. You've probably heard a lot of training about unconscious bias, but that would come into it as well here. So the motive's irrelevant and doesn't prevent a finding of discrimination being made. So the next strand really is about what I would call indirect discrimination. This is section 19 of the Equality Act, and that's where an employer effectively applies a rule, what we call a provision criterion or practice, or a PCP, to everyone which is discriminatory in relation to a protected characteristic, so it adversely affects a group of people such as cancer sufferers here, okay, places them at a disadvantage to those who don't suffer it. Now, these types of claims, unlike direct discrimination, can be defended if the employer can demonstrate that the application of that PCP is a proportionate means of achieving a legitimate aim. Okay, so for example, if you apply a rule to everybody that they have to work between the hours of 8 o'clock and 4 o'clock, okay, that may disadvantage cancer sufferers because they may find it more difficult to get going in the morning, for example. It's a rule that applies to everybody, okay, but indirectly impacts on the cancer sufferer, okay. But an employer may be able to justify that rule if, for example, the vast bulk of its business and calls come in between the hours of 8 and 10, for argument's sake. Okay, so the most common PCP for employers to use is the requirement to work full time, which might disadvantage people with disabilities, for example. The other strand of discrimination I wanted to talk to you about was harassment, which is a word that's often bandied about, but does have a strict legal definition. And that definition is that a person A harasses another person B if they engage in unwanted conduct related to a protected characteristic, so disability here, which has either the purpose, not many people do it deliberately, or effect of, which is critical, of violating an individual's dignity or creating an intimidating, hostile, degrading, humiliating or offensive environment for B. So the sorts of examples that you often see might be comments made in the workplace such as, oh, I'm fed up of having to cover for Dave all the time. He's always playing the cancer card and whinging on or whatever. Okay, and those type of comments would effectively fall squarely within the definition of harassment. And it doesn't even have to be Dave in that example that is the comments directed to. If I have the disability, okay, then ultimately the comment might not be directed about me or you know, it might be somebody I live with. For example, I'm sick of him having to leave at 4 o'clock to look after his brother, for example, or his mother or whatever. Then you might fall within those provisions really. Now, there is a duty on employers under the Health and Safety Act, at Work Act, to ensure as far as possible, reasonably practicable, the health and safety and welfare of their employees. And there's a broader implied duty to provide a suitable working environment for employees. Now, the definition of harassment expressly catches conduct related to a protected characteristic. So, like I say, it also covers associative discrimination. So, you know, if you're making comments about somebody else, okay, and it offends somebody, but it also covers perceived discrimination. So if people are perceived to have a disability but don't, okay, then they may fall within that category as well. And it's important to really understand that if you are an individual seeking to bring a claim for harassment or discrimination of any kind, for that matter, then you have to sue your employer, okay, under the principles of vicarious liability, but you can also, unlike unfair dismissal, sue the individual harasser as well, okay. And the reason that's important is that the tribunal can, normally the employer would stand behind the individual harasser, okay, because they're liable for that individual's acts. But if the employer can show they've taken all reasonable steps to prevent the employee effectively going rogue and acting in the way that they did, the employer can hang that individual out to dry. Okay, so if I went round at Irwin Mitchell and started making offensive remarks to everybody, okay, which offended a number of people, and Irwin Mitchell had trained me in equal opportunities, they'd shown me the equal opportunities policy, they'd told me that it was unacceptable to be making offensive remarks to people, and said that if I did do that, then I'd be subject to disciplinary action. And in this example, I was dismissed from my employment. Then Irwin Mitchell could effectively cast me out to dry, and it would be me that would be responsible for the award. Okay, not Irwin Mitchell. But remember, employers have got deeper pockets. Okay, so you have to sue the employer. Okay, but tactfully you might want to sue the individual as well to try and drive that wedge between employer and harasser. Okay, so the last, well, the other main strand of discrimination is victimisation, and that again is a word that's often used but often misunderstood. And that's where a person subjects somebody to a detriment because they've done a protected act. So that's either that they've brought proceedings under the Equality Act, okay, or they've given evidence or information connected with such proceedings, or raised an issue that they are being effectively an allegation that they are being discriminated in a way. So, for example, if I bring a grievance and then all of a sudden I'm dismissed from my employment, that will be victimisation. That will be a victimisation claim. The one that usually arises, though, in a discrimination claim, well, there's two really. One is this concept about discrimination arising from disability, and then the other is this key concept about reasonable adjustments. Discrimination arising from disability is the one that I think is often the most important, because whilst this doesn't require a comparator as such, it focuses on whether there's less favourable treatment because of something arising in consequence of the disability rather than the disability itself. So let me give you the best example. If I'm dismissed from my employment for my absence, I'm not being dismissed because I have a disability. Okay, I'm being dismissed because of something that arises from it, i.e. the level of absence that the employer cannot withstand. Okay, so that would allow me potentially to make a claim under Section 15 of the Equality Act. Okay, and you know, if, for example, an employer goes through a trigger point system that says, you know, if you're off 3 times, you get a stage 1 warning. If you're off again for a week after that, you get a stage 2 warning, and a further strike after that, you're out the door. But employers can effectively justify why they've taken that action, so it can be justified again. So essentially they can say we can't withstand that level of absence and therefore we're entitled to do it, notwithstanding that it is regarded as discrimination arising from disability. Okay, and what does this really mean then? Well, the starting point is that an employer can't be held liable for discrimination if they didn't know or could not ought reasonably to know that their employee had a disability in question. Okay, so if I dismiss somebody and they come along to meetings and they say, yeah, I've had a bad throat. The next meeting they come along and say, I've had diarrhea. And the next meeting they come along and say, you know, I've had some stomach problems or whatever. If I don't know that that was cancer related or something that could amount to a disability, I cannot be on the hook for disability discrimination. Okay, so in terms of advising individuals, my view would be that you need to carefully consider when to raise the diagnosis, okay, with the employer. Okay, obviously the earlier you raise it, the more protection that individual has in relation to disability discrimination, because if the employer didn't know or couldn't reasonably ought to know that the employee had a disability in question, then they can't be on the hook for disability discrimination. Okay, or the requirement to make reasonable adjustments, for example. So you also need to consider the who you tell at your employer and how you do it, in my view. But ultimately, it's key to place the employer on notice in order to have the protection of the legislation. So once you tell the employer, that person is not in a complete bubble, but it does trigger various obligations on the employer themselves. And what the employer can't do is it can't just stick their head in the sand and say, you know, I'm not listening if somebody tries to tell them something. But they may not be deemed to have of knowledge if there's no information, or they can't reasonably be expected to know. And I think that's pretty important. Okay. In relation to the duty to make reasonable adjustments, these are found at sections 20 to 22 of the Equality Act, and they place an obligation on an employer to make reasonable adjustments to a disabled employee's role where he or she is placed at a disadvantage in comparison to people who aren't disabled. So the clues in the title, it has to be a reasonable adjustment. Okay, it can't be something that's, you know, completely unreasonable. And considerations also given here to the size and resources of the employer. So the bigger the employer, okay, and the bigger the pockets they've got, the more they're expected to do. Okay, So examples of the sorts of reasonable adjustments that we're talking about might be things like the introduction of auxiliary aids, the change to working hours will be a big one, the change to work locations so it's more easily accessed, particularly at the minute, for example, would you work from home, allowing time off for medical appointments subject to reasonableness. It doesn't have to be paid, it can be unpaid if the employer wants to do it that way, but they can't subject somebody to a detriment for doing that. The most common example though would be the change to any trigger points for any disciplinary warnings. So in my example before, where it's a sort of 3 absences and you get a stage 1 warning, should that be 6 or 9, for example, or a longer length of time? And how would you change somebody's working hours? And the key really for the employee and for you guys advising employees and for the employer really is to get into a dialogue. Okay, so if the individual finds it difficult to get up in the morning, can those working hours be changed? Can they, for example, be allowed more breaks from the desk during the day? The law doesn't require an employer who, when faced with an employee who can't do their job, to create a new job for them. This is one of the questions we got asked in advance. Okay, so if you are, I'll use the example that was given, a refuse collector, and you can't do manual handling, okay, and there isn't a machine that can help with that, for example, or you can't be the driver of the truck, for example, rather than the person filling up the truck. Okay, the law doesn't require you to effectively create a new job for that person, but what it does require you to do, and this comes from a case of Archibald against Fife Council, is that it may require you, without competitive interview, to slot somebody into a role that is available. So in the Archibald and Fife Council case, there was actually a bin collector and a road sweeper, I think it was Mrs. Archibald, and she couldn't do that job anymore. And there was a job as a filing clerk within the council. And the council said to this woman, well, look, you can apply for the job, but you'll have to go through a competitive interview process. And the Employment Appeal Tribunal, ultimately, obviously it went to the Court of Session, I think, in Scotland. And they said, well, OK, there was a job there that on face value that individual was capable of doing, and therefore you should have slotted Mrs. Archibald into that job ahead of any external candidates for the role as a reasonable adjustment. OK, so it's pretty important that that is considered for employers. And again, it's for the employer to work out what the reasonable adjustments are. But in my view, if the employee can suggest some reasonable adjustments, and therefore you advising them can suggest some reasonable adjustments, you should do so. Okay, can I be given a person to help me do this role that involves half an hour a day? Can that particular aspect of the role be taken off me and given to somebody else, and I'll do this particular aspect of the role, for example? Can I start work at 9:30 rather than 9 o'clock? Because I don't have to come in on rush hour, and whatever it is really. And I think it's pretty important that employees should suggest things as well, albeit the duty is on the employer to make the adjustment, not the employee to suggest them. The reason why it's important to suggest it is that if they don't suggest it at the time, the employer will say, well, actually, we wouldn't have known that was a reasonable adjustment. Okay, and that's why we didn't make it. Okay, can you just move the slide on, Olivia? The other thing I wanted to talk to you about today really was about this concept about permanent health insurance, or what's now called group income protection, because this is an area that comes up quite a lot with cancer sufferers, okay, and people with long-term disabilities. Okay, and often it's overlooked, or people don't even realise that it's a benefit that they're entitled to and have in the contract of employment. So the key for employees to start off with is to check whether they've got the entitlement to group income protection in the contract of employment. Okay, and what group income protection is it's a policy of insurance that's taken out by an employer with an insurance company, okay, on behalf of its employees. So for example, you've got Irwin Mitchell here, the employer, you've got the insurance company here, AXA, Standard Life, whoever here, and you've got the employees at the bottom here. And there's no contract at all between the employees and the insurance company at all. Okay, there is a contract between the insurance company and the employer, Irwin Mitchell, and there's a contract of employment between the employer and the insurance company. Okay, and the employee in my example, but no direct contractual link between the employee and the insurance company. Okay, and what group income protection does is that it kicks in to pay an amount of an individual's pay, so their salary, for a period of time, okay, when they are incapacitated from a particular occupation. Now, I say incapacitated because the rules of the insurance contract between the employer and the insurance company will differ, okay, and therefore affect the employees differently. So some insurance contracts say we will pay 75%, for example, is fairly common, of the employee's wages up to retirement date or 60 or whatever it is, in the event that the employee is permanently incapacitated from work, okay, the work that they do. Some insurance contracts will say we will pay 75% where the employee is permanently incapacitated from any work. Okay, now there's quite a big difference between those two things, because I might not be capable of doing the work that I do, but I might be capable of doing some work, and in the latter example the insurance policy wouldn't kick in. Okay, and it might be that I'm incapacitated from doing it rather than permanently incapacitated from doing it. So if there's a chance of recovery, for example, depending on the wording of the insurance contract, it may not kick in. So what tends to happen, okay, is that insurance companies don't like paying out substantial amounts of money, in my experience. Okay, so the individual would need to find out whether they've got the benefit of permanent health insurance or group income protection, okay, and then liaise with their employer about how to make a claim. Okay, and the key bit, and why I explain the importance of the tripartite relationship, is that whilst there is no direct contract between the individual employee and the insurance company, the law implies a term into the contract of employment for the employer not to terminate that individual's employment so as to deprive them of the benefit of the permanent health insurance. Okay, because if you're not in employment, in my example at Irwin Mitchell, you don't get the benefit of the payment from the insurance company. So the law effectively implies this duty not to, in this case Irwin Mitchell, to deprive me of the benefit by terminating me, save for if I commit an act of gross misconduct or I'm redundant. Okay, so if Irwin Mitchell do terminate it, in my example, and an individual's either on PHI or could reasonably be expected to go on it because they're about to make an application, for example, it's likely to be successful, me as the individual can sue my employer, not the insurance company, okay, for breach of contract. And if you think about the damages for that, I'm currently 42 years old. If I was going to work until I was 65, and let's say I earn £20,000 a year, the damages could be huge. Now you can swap out different ages numbers, but they're always going to come up with a big number at the end of it. Okay. Now the position's different if that individual's unlikely to be successful. But for you guys advising people with cancer, this is an absolutely critical benefit to look out for, okay, and to consider how to deal with the employer in that regard, because it may well be that the employer should, if the individual is knocked back on first application, take steps to support the individual employee in appeal, for example. You know, so if there's a reasonable chance of an appeal, they still shouldn't terminate their employment whilst that's pending. Okay. Now this comes also in the case of discrimination cases, because people will say, well, look, it's a failure to make reasonable adjustments in not facilitating that appeal. Okay, but it's not a benefit that's at no cost to the employer, because holidays continue to accrue during PHI. Okay, and sometimes the insurance company might want to buy off the right, so you know they will keep it under constant review. So you see examples where the insurance company would say, look, if the individual's on this till the age of 65 or whatever, and it's going to cost them 400,000, we'll give the individual 300 grand now, okay, and they'll take the chances, because obviously if the individual comes off PHI at any point, okay, then it could be to their detriment, basically. Can you just move the slide on? Okay, so I just wanted to talk to you. Obviously, we're in the midst of a global pandemic as things currently stand, and up until the end of this month or this month, we've got people shielding from their from going outside and the like, and from probably coming into their employment if they've got cancer or other such conditions like that. And we've been advising a lot of employers in relation to people who are shielding and are concerned about coming back to work by virtue of the impact that COVID-19 could have on them by returning into the workplace themselves. Now, whilst the shielding requirements will cease, but as per the government guidelines very shortly, employers will still be under a duty to make reasonable adjustments. Okay, and part of those reasonable adjustments, for example, would be to give the shielding person or the previous shielder, okay, the least public facing job, okay, so as not to expose them to COVID-19, for example. Okay, it may apply, for example, to somebody who is living with a shielder, okay, and you may need to make adjustments for that person. Okay, the employer may need to make adjustments for that person so as not to effectively risk the person who suffers from cancer when they go home, possibly with the with COVID-19. So you, as an employer, you shouldn't make assumptions about these things, but you have to do a risk assessment now under the new government guidance, and the key is really that it's not a standard risk assessment for all the employees, and you effectively will need to take into account special categories of person, which will definitely include people who are suffering from cancer, given the increased risk of that. Can we move the slide on, please? So that's all I really had to cover. Okay, we've got some questions, but equally I think people can post some chat in the boxes, and we'll go through those. So in terms of I think I've answered the first one in relation to if you're fit to work but not able to do the job you're employed to do, can they, and they want to end your contract or force you to retire on medical grounds, can they do so? Well, like I say, subject to that Archibald and 5 case, where there's an obligation to look for alternative work and roles that are available, you're not required to create one, but you will have to slot people into one if there is one available, or adjust the role that they currently do to make sure that they can do that role. The next question I had was, I had a cancerous tumour removed in January and returned to work in March. HR said they would arrange an occupational health appointment with a view to a phased return. This never happened, as it turns out. The HR manager went on a career break, which is obviously helpful. I've therefore been working full time since. I'm feeling quite tired now. Is it too late to take any action with HR? I know being passive in this way may not have helped. I'd appreciate any comments you've got. Well, it's not too late is the straightforward answer. If your circumstances have changed and you are feeling more tired than you were previously, or don't feel that you're able to cope, then you should definitely raise that with your employer and discuss the concept of reasonable adjustments. Obviously the phase return's now gone, but it doesn't mean that you're necessarily capable of doing a 5-day working week. It may be that you have to go to your employer and say, look, I don't feel well enough, I'm too tired, I need to consider reducing my hours either for a temporary period or permanently, and the employer will need to consider that by way of reasonable adjustment. And if they don't, and you might want to tack on the fact that they've not done that so far despite occupational health involvement, then you may need to raise a grievance about the treatment, okay, and or potentially a tribunal claim. Now, I'm not advocating necessarily people to make tribunal claims, but obviously if your employer refuses to listen and there is a duty to make reasonable adjustments, then that is your ultimate remit to go off to a tribunal and complain about it. So to give you an example of the type of thing that we see, I act for a company that works on a government contract fitting tags, electronic tags on people, and then they'll go out to people, they'll get a call out in the middle of the night. We had an individual that was that needed to be within 20 minutes of a toilet because of a medical condition that they had. Now, clearly the employer needs to consider whether they can accommodate that adjustment or not. And the critical real piece of this really is, you know, to what extent is that a reasonable adjustment for the employer to make? Well, if they need to be within a certain distance of a service station, for example, then they can probably do it. depending on the geographical area that they're in. But if they need to be within 20 minutes of their home, okay, and the patch that they work on is a large one, and ultimately it's not going to be profitable at all or feasible to allow somebody to work within that very small radius, then it wouldn't be a reasonable adjustment. So, you know, it will depend each time on the circumstances. But going back to the original question, if you can't or you don't feel you can work the current arrangement that you are working, then my view is that it's never too late to raise that as an issue, and your employer would still be obliged to consider it. Simone, do you want to deal with the question that's been asked of you about industrial injuries benefits?
Yeah, sure. So I had a question about cancers where somebody might be entitled to industrial injuries disablement benefit. So that's a government Department for Work and Pensions benefit where someone's cancer has got an occupational cause. So the short answer to that, actually, it's easier if I direct you to the government website. We'll post a link for that. So basically there's a week, just as somebody with cancer might be entitled to Department of Work and Pension benefits for care, there's an industrial injuries disablement benefit that's payable for certain prescribed industrial diseases, including some cancers where there's a work-related cause. So if someone's been exposed to a carcinogen in their work, you know, noxious dust or fumes or chemicals, and that's the cause of their cancer. So, for example, some cancers of the lung, nose, liver, lung, there may be an occupational cause. So it's important then for somebody to get advice from a welfare benefits advisor to look at whether they fulfil the Department for Work and Pensions criteria for that, whether their cancer is one of those prescribed industrial diseases. So it's too detailed for me to go through on the webinar, but we'll post that web link to these. There's a technical advice document in connection with industrial injuries disablement benefit on the Department for Work and Pensions website. So thank you for that question. Maybe I can pass back to Glenn. There's a question about somebody coming back to work in September who's had cancer, been shielding, and their concerns around public transport and whether they should be allowed to work from home. I don't know if you're able to help with that one, Glenn.
Under the new government guidance, it's surprisingly scratchy about what the obligations on an employer is as regards to people getting to work, as opposed to what their obligations are when they're at work. But it seems pretty clear to me that the guidance isn't just related to those who are at work, and it does go a little bit beyond that. And my view is that, well, the government guidance has always been relatively clear about this, is that if you can work from home, you should work from home, quite frankly, as things currently stand. Most employers are bringing people back. I think if it means that a person who is or has been shielding is exposed to greater risk by travelling on public transport, in my view, the employer needs to consider with that individual whether there's an adjustment that can be made. So, for example, does the employer have a car park? And if so, can they allow that individual a car parking space for a period of time to effectively reduce the risk of infection? And can they allow them, for example, to come in at a different time of day, so they're not crammed into a tube or a bus at rush hour, if there is such a thing these days? Okay, so could they, for example, start at 10 o'clock rather than 9 o'clock, so they again reduce the risk of infection? Is there some equipment that they can provide, okay, that effectively would reduce the risk of infection, such as a better face mask than what you or I might be able to buy off Amazon or whatever? So there are steps that can be taken. Again, I think it forms part of the risk assessment that an employer would need to do, in particular reference to vulnerable people. So if you think about the government's classification, in England, certainly it's different in Wales and Scotland. The government had these people who were vulnerable people, and they also had the clinically vulnerable people, so the guys that got the letters straight off the bat, like my brother, for example. And you as an employer, I think, need to sit down with employees, and I think if there's concerns from an employee side, I think you need to raise those with your employer, because in my view, most employees currently should probably still be working at home unless there's a good reason not to do so. And it may be, for example, that we've just been talking to an employer recently whereby they've put a one-way system in their office. They've moved the individual's office so they don't have contact with people, or certainly less contact with people. But it is a requirement for that individual to go in because they need to be listening to what's happening. They need access to some equipment that can't be provided at home, for example. So it is again part of that dialogue. I think it extends beyond the being at work provision. It's the getting to it as well, provision as well. Have we got any more, Simone? And I think somebody said, sorry, she doesn't drive. Well, yeah, well, look, you know, ultimately, it may be that then an adjustment would be to work from home. The adjustment could be to get a taxi in, and as to who foots the cost for that is a different issue in my view. Now, cost may form a part of a reason as to why something is not a reasonable adjustment, but it shouldn't really be the only reason. But clearly, if you have to travel 50 miles in a taxi to get to work, that's one thing. If you have to travel 2 miles to get to work, that's another. Or you could walk, or get you know, some other form of, you know, a neighbour to drop you off, somebody to pick you up, or whatever. You know, so clearly it forms a part of whether that adjustment's reasonable or not. Okay, and if what we are seeing is that we are seeing examples of people who aren't comfortable in returning to work. And I think the advice differs depending on the reason for not returning. So I think an employer will be very brave / stupid, in my view, to potentially terminate somebody's employment for you know, if they can't come in on public transport for, say, a period of a month, 2 months until things calm down. I think that's a very different position to, say, taking immediate and decisive action for somebody who's just enjoying themselves on furlough, okay, doesn't really want to come back to work. And certainly I've seen examples of both, really. And the advice that we've given to employers, and that's, I say it from an employer's point of view because that's where I give most of my advice, has been very different in those two scenarios. So in my view, the employer would have to take that position very seriously and sit down and try and work out whether there's something that they can do. And if they can't do anything and the employee can't work from home, you are into that potential scenario of potential termination of employment, okay, and that balancing exercise I talked about before. Okay, but you would still have to jump through those hoops. Have we got any more? Somebody said Archibald got to the House of Lords. Yeah, okay, that's fine. Sorry, somebody said we've got pregnant staff who, according to government guidelines, should come in, but the doctors have told them not to. Yeah, well, I think pregnant people are again a category that are separate to everybody else. I think. You know, so for example, I had 2 people who were just about to go on maternity leave when the pandemic hit, and we sat down with those individuals and we discussed it. There's no reason why they couldn't work from home, so they went straight away and worked from home, because we didn't want to expose them to any risk. But I think the conflicting guidance is interesting, really. So we are seeing examples of doctors saying that you shouldn't go in and people actually wanting to. And I think employers are very concerned about the risk that they expose themselves to about asking people to come back in those situations. We've seen examples of shielders who want to come back despite the fact they can still technically shield, and it's predominantly for pay reasons most of the time, okay, because obviously shielders only necessarily need to receive SSP, whereas they might want to receive the full wage. But ultimately, again, it's just that risk assessment point. It's the same as everybody else, really, to assess the risks, see whether you need to take duties off the pregnant person in that scenario, see why the doctor specifically is saying they're not entitled, why they shouldn't be going back. But remember, if you suspend somebody on medical grounds, so you suspend somebody because it's not safe for a pregnant person to come in, it automatically triggers the duty to pay them in full rather than SSP. I think that's all we've got, Simone, to be fair. So from my point of view, I hope people have found it useful. I'll hand over to Simone to talk through the next steps.
So thank you, Glenn. That's been very helpful indeed. I know I've learnt a lot there, and the actual sort of case examples were very helpful as well. Thank you for the questions there from everyone. So just to mention that there's some further information available on our Irwin Mitchell website, and in terms of keeping people informed during this season with this coronavirus hub with updates and other webinars that we're offering. If there are particular topics that it would be helpful for us to cover, then please do contact us through the events at Irwin Mitchell email address, or to Glenn and I directly. We're happy to try and help with other topics in the future. And also just to mention, obviously, for people with cancer, there's a wealth of information and support out there from their local hospitals in terms of cancer support charities, and the Macmillan website's got lots of great information with sections on employment issues, financial issues, and obviously practical and emotional issues as well. So and they can often put people in touch with people locally as well. But I hope this session has been helpful, just to sort of highlight occasions when people may need signposting to a solicitor for further advice if they're in a difficult situation with cancer or recovering. So do let us have any feedback. There's a link in the chat at the side there where you can post some feedback. Otherwise, I'd like to thank Glenn very much for that very informative and interesting presentation. Thank you. I know I've learned a lot. And thank you to Olivia and our events team for making this happen. And yeah, do get in touch if we can help with anything else. But otherwise, thank you very much for joining us, and cheerio for now. Thank you.